right. Welcome to another edition of You and the Law. My name is Jermaine Levy. I'm the founder of this movement. I teach law, and I'm going to give you a little bit of my history. But today's episode, we're going to teach you basic introduction to law out of Module 1. This course was designed to help criminal defendants help themselves. In prison, I was fighting a lot of cases and winning a lot of cases, and I kept meeting good people who just had a lot of issues, but it was too much for me to handle. So I decided to start a course, You and the Law. Through the course, we usually get about 30 to 50 classmates, and we get about 3 wins in the average quarter, in the average 16-week module. So what I'm doing right now is I'm introducing it to you and everybody in Ohio. I'm about to introduce the course on your tablets, likely for free. I'm trying to get that arranged now because the course is available right now for a fee for $600, but I'm trying to make it where I can give it away free and get you your 5 good days off or your 1 good day if that's what you qualify for. So I'm in negotiations with that now, and I'll have that resolved within 45 days, hopefully. But to say all that is to say that this movement is for the people, from the people. My name is Jermaine Levy. I did 25 years straight. I just got out about 23 months ago, and I manage a law firm, and I got this company, and I got a paralegal company, and I just want to welcome you to our show. I want to help you, be an ally for you to help yourself. We're going to have re-entry components of the show. We're going to have educational components of the show. You can contact us on your tablet if you got GTL. If you didn't have GTL, you're not viewing, so you do have GTL at info@youandthelaw.org. That's your direct email to me, info@youandthelaw.org, where you can send your questions in and we'll address them. We can only identify you by initials out of respect for privacy, but we would like to hear from everybody, and tell all your friends this movement is here, because law is the elephant in the room that has been hurting us for years. Whether it's just not criminal law, it could be child custody court, it could be criminal courts, it could be probate courts. It's a lot, and this is generational. So what I want to do is just try and teach. If you could take your time to apply yourself, this will be the modules. I have a weekly newsletter up there right now, and it's in 5 different languages. So if you go to the enter You and the Law in your GTL tablet on Edovo, the newsletters pop up. Start reading them, and then I'm going to actually start teaching. Today it's going to be the first day. I'm going to go through several sections of the course, module by module. I'm going to start today with module 1, because I like to teach you. My job is to make a better you. And a lot of people are starting to write me and ask me, can I take their case? What I want to do is I want to teach you. I'm rebuilding my life, so I don't have time to necessarily take a case by case. This is not a legal clinic. This is a legal educational initiative. So I want to help you. And the course is designed where if you got a 6th grade reading level, you can handle it. But I'm actually finna give it to you orally also, because I want to reach everybody and I want to make this movement work. Now, with that said, my guests here today, I have 2 special guests, and I would like to ask them, are any questions they have off the initiative that could just maybe be answered? And maybe I'll turn to you first, Derek. You got any questions?
Oh, excuse me.
Caught him dead off guard.
Oh, yeah, excuse me. Good afternoon. I think that one of the bigger questions that most people, as a formerly incarcerated person myself, someone who's been in the law library, someone who has had the opportunity to do some of their own legal research in order to help themselves, one of the bigger questions, and I'm certain that it'll be addressed in one of the modules, is just how do I begin my legal research? When I'm looking at my case, when I've been sentenced and now I'm here in the institution and I get a pass to go to the law library, what is the first step, or what's the first thing that I should be doing when I get into that law library? Because obviously I have no legal background. Obviously I have no, and I'm kind of in a crossroads because, being honest, I just want out of this time.
Okay, 100%. I can agree. That's how this course was founded. Now, may I respond? That's your question?
That's
okay.
it.
That was an awesome question. I'm going to tell you why. I got the answers, but I might necessarily know how to follow this. So that's why I got them here to give me directionals. Now, the first thing you should do, as soon as you get convicted, if you didn't do an appeal, if you pled guilty, if you did trial, you definitely supposed to exercise your right to appeal. If you pled guilty, you have a right to appeal, but you might got some sentence you can live with. But to better yourself, you can still order your trial transcripts from the court reporter. They only used to be like between $30 and $140, depending on if you had a long plea colloquy or a short one. But you want to get your transcripts. You want to get your indictment. You want to get a copy of the statute you were convicted under, because those are the essential tools necessary to learn from the beginning. Now, in this course and in module 1 that's already on your tablets for free completely, the module I'm about to go on is actually on your tablets already for free in one of my legal newsletters. It's called Bonus Educational. It's on there for free. It's one of the bonus newspapers I put on there. The first thing you want to do is get a copy of your record. The second thing you want to do is carefully review it. And I would recommend to take the shortcut, go through my newsletters and see what type of cases trigger bells with you. And when they do, start reading those cases, because I know law, but you know what happened to you. So every newsletter I do is like 50 pages long. And each page has like 6 to 10 cases on it. So it's maybe 200 cases explained in each newsletter. And I did it long like that because while we're incarcerated, we have all the time in the world. So I would suggest, what do you do when you first want to start with your case? First, get your trial transcripts and your record and your plea colloquy and your indictment. Second, set 2 hours a day aside to study, because I'm going to tell you a sad truth. I was reading a case one day, and this judge was like, this guy was time barred, and he said he let himself get caught up in the creature conference. So listen, they have the basketballs, they have the chessboards. You're going to have your recreation, you're going to have your workout, because, health is wealth. But give yourself some time to grow. So I would say just take 2 hours a day to commit to reading something that's educational. And the good thing is, I summarized it for you. This course, You and the Law, this whole movement was designed to teach you. I taught law in prison for 18 years, so I understand how to communicate with you. I've had students who couldn't read, and I had to help them go get their GED first. They came back, and they're actually teachers now. Law opens up a beautiful you because you learn to grow. It's challenging, and it's not challenging in the way that's defeating. It's challenging in the way it shows you how swift you really are. You think lawyers are some gifted angels? No, they just study. We can read. We read very well, but instead of reading entertainment books, read something that actually grows you too. Get a good balance in the mix. So today I'm going to start with the purpose of this course is to introduce you to law generally. The second is to introduce you to case law and statutes and teach you how to dissect them so you can learn how to craft meaningful arguments. That's the core goal of the course, because if you can learn how to dissect case law, learn some law, you can have a meaningful conversation with your lawyer. Lawyers love when they got a great client. The worst thing you want to, and plus right now, most of you are probably on your own, and this course is designed to make sure that you do not get defeated by law. I've never met a man who applied himself who didn't win. When I say that, it might have took him 10 years, it might have took him 14 years, but they all had like 2 life sentences, 3 life sentences, 5 life sentences. So by the time they got down to there, my guy, Haziz, he just had 14 life sentences. He finally cracked his case and ended up doing 23 years. You say, oh, I don't want to do 23 years, but you definitely don't want to do 14 life sentences. So these are the tools that you can arm yourself with that actually make you a better man and grow. And then there's different opportunities because it's just good social growth, and there's awesome career opportunities within this. The law field is not regulated. You don't even need nationally, you don't even need a license to be a paralegal. You just got to work under a lawyer who approves of your work. Now, you got to become the best to do that. While I was in the term jailhouse lawyer, you got some very smart men in there. And as an initial, I'd like to shout out this guy called Speed. He's a good brainiac in there that I love to work with. If he came home, I met him. I meet certain guys who impress me, Jughead, Mac. I got some friends who are just awesome. And it's like, if you become a part of this community, you can definitely grow and help yourself and help people that you care for. Now, this particular podcast was for me to explain all that, I want to begin by teaching you some law. So, base one. Let me see. Let me go to module one. Hold on 1 second, y'all. Begins on page 5. I wrote the book, so I should know it, but I got to go so I can teach you where to go to. Okay, now. Okay, module one. Okay, I go to pre-course tips. Module one is called pre-course tips. It's tips to give you, to guide you in a direction on how to build yourself, how to get trained to get ready for this fight. So pre-course tip one, the number one rule of law, the number one thing you got to learn to do when you start presenting yourself is it's a rule of litigation, and there's 2 rules cannot be understated. That's one, that the issues are framed by the parties. When I say that, and this is important, the issues are framed by the parties. That's the number one rule of law. You may ask, was I denied my right to confrontation because this happened? And the court might deny you and say no. And you say, man, that wasn't right. You're correct. It wasn't right, but it wasn't a confrontation clause violation. It could have been a denial of due process, which is just a process you were due. It could have been the denial of the effective assistance of counsel. It could have been a Rule 404B violation. It could have been an evidentiary rule violation, but it wasn't a violation of the confrontation clause, and that's the question you asked. So the number one is 2 rules of law that are absolute concrete in litigation. One, the issues are framed by the parties. That means identify your issue correctly and present that exact question that you already should know the answer to. Second, the facts of the case dictate the outcome. Most people lose based on the application of their particular facts. You might be like, well, he won, and my case is worse than his. But you might not, you might not have asserted the correct facts to present your claim squarely. The facts dictate the outcome. So as that's what this course teaches you, I teach you in this course how to dissect case law. And I can do this right off the top. Any case law in the world, like the first thing you want to learn is the site. The site is the case's social security number. Like my case is United States versus Levy, 250 Fed 3rd, I think 216. But anyway, and it's 6th Circuit 1999, it's my federal case. But that's the site of my case. That's like social security number. It's only one guy at 250 F.3D, just imagine, say, page 216. 6th Circuit 1999. That's going to be the beginning of Jermaine Levy's opinion. Now, the second thing you want to recognize with any site is the question presented. With any case, rather, the question presented. The question presented is important because it dictates the outcome, because it's what they're necessarily going to answer. When you ask a specific question, they're going to answer that question and that question only, because their job is referees to tell who won the fight. Their job is not to reframe your question for you, ask a better question for you, or ask the right question for you. So if you take your time and study this course, it's going to teach you how to dissect case law and understand the question presented first, because that question presented is the one that might be relative to your case if this case you're reading is applicable. Now, you want to learn a site. Second, you want to learn the question presented. Third, you want to learn what's called a holding. It's like holding, Holding. The holding is the court's answer to the question presented. So when they answer the exact question presented, that holding only applies also under his facts, because your facts may be different. Like you may have an awesome violation of you might have an awesome speedy trial violation. You might got a statute of limitations defense that was just 100%. But he won, but you may have waived your right to appeal it. So just because the issue is a winner, you got to make sure you got the facts to allow you to win. You didn't exercise an appeal waiver. Appeal waivers don't scare me. When you know law, when you see waiver, you want to see what's it knowing, intelligent, and voluntary, because waivers can be defeated. Knowing, intelligent, and voluntary means you knew what you were supposed to know entering into this particular waiver. It was an intelligent move, like a person intelligent is like a person shouldn't plead guilty to murder who only got in a wrestling match. Voluntary means knowing the rights and the procedures at bar and all the benefits I have, I'm agreeing to waive these on my own free will. So knowing and voluntary is really the main two. Knowing, like to plead guilty to a particular charge, you should know the elements of the offense. You should know the minimum maximum penalties. You should know whether the term is required to be consecutive. You should know whether a merger applies. If the law says you are entitled to know this and you don't know this, then your plea cannot be naturally knowing. I didn't know this particular component, but that's why the law is so beautiful. The law evolves. Like one thing I want to teach you coming out the gate is that the Constitution evolves. The Constitution is a living document. The Constitution was written hundreds of years ago, but it's a living document. So I'm going to tell you what I mean by living document. It's subject to interpretation. The Constitution says what the sitting justices say, what the United States Supreme Court or the higher Supreme Court or even a particular appellate council. That Constitution says what they say it to say. You say, what you mean to say what it say? No, that's your interpretation of these words. But they could take these words and say, like to give you a perfect example, the death penalty for juveniles or in general. 10 years it'll be constitutional. 10 years later, the next one to say that's cruel and unusual punishment. Then they'll override that, say no, it's accepted by society as a reasonable means of punishment. So the Constitution ain't changed. The Eighth Amendment has said for hundreds of years, cruel and unusual punishments shall be banned. This particular justices that's sitting for these 20 years say, well, this what constitutes cruel and unusual, to execute somebody who under 18, or to execute somebody who under 21, which is not the law, I'm just giving you an example, or to execute somebody who's mentally disabled. But that's why I say the Constitution is a living document. The Confrontation Clause is absolutely beautiful example of that. From this case in like 1982, they were saying as long as it has an indica of reliability, let it in. In 2004, a case called Crawford versus Watch came down and said, y'all been wrong for these whole 20 years. Everybody got life off of them. But 20 years later, they say, no, we were wrong. And this is what the Confrontation Clause demands. And they keep refining it. The latest case on the Confrontation Clause is Smith versus Arizona. I will recommend everybody reading this who is on direct appeal to absolutely read that case, please. It's one of the most beautiful cases for defenders the Supreme Court released. And what it says is an expert will come on and say, well, I come to the conclusion that that's his DNA that was found on that doorknob. But he's based his conclusion on tests done by other experts. The Supreme Court said, no, get that out of here. Bring all of them in here. If he object. That's why, and when I say if he object, if you don't object, you're going to plain error. And under plain error, the first thing is you got to be clearly established law for it to be wrong. If it ain't clearly established law, it ain't wrong. But if you object, you can be using prior precedent that leads to this conclusion. Precedent mean controlling case law. So the tool is learn. When you learn, this system can really be fought if you learn, but you got to have the right tools. It's not as hard as you think. I'm talking a lot and fast. So I'm going to slow down right here because I don't want to overwhelm you and bum rush you. But this is a beautiful subject. I love it. I love to see people go home to their families. And there's a few people who hopefully watching this that I'm trying to win for you right now. And I'm all in and I'm dead serious about it. Now, with that said, Miss Melissa, would you have any questions so far?
I actually did have a couple questions in the beginning. And then you answered all of them. And then
Excuse me. Okay.
my question was his. I was going to ask, where do you start? And then he asked it, so I'm waiting.
Well, thank you. Okay, and
I'm actually understanding it.
Thank you. The purpose of these two guests is I know law and I love law. But as I talk, you may have questions, but I can't talk to you live. So they're here to just throw questions at me that they might think. Now, with that said, Derek, anything trigger any questions from you right now?
Yeah, well, just to go a little further, I mean, based on what you've explained already, we've talked about, you briefly touched on dissecting case law. You talked about precedent cases and things like that. I think that one of the things that often scares people is the language. You know, okay. For many guys, you know, sitting in that law library, you know, I've sat there and I've witnessed it. One of the things that happens is a lot of the cases and a lot of the arguments are excluded because of the language. You know, so let's kind of, I know you want to go through your modules, but let's talk about certain things. Like that was one of the things that was a very controlling and prevailing instance in terms of individuals, which you use the term jailhouse lawyers. You know, the majority of the quote unquote jailhouse lawyers are those guys who they're not spending a whole lot of time at the chessboard, and they're not spending a whole lot of time at rec. Or so they're in that because they've got it in their mind that they want to, that their goal is to try to make it up out of there. Or like you said, much like you said, help others try to make their way up out of there. Now, when we start talking about the language, let's talk about some of the things and some of the obstacles that individuals inside of those institutions, those guys that don't have the necessary the language and understanding the whole pro se process.
Now, that is another awesome question. You want to know why? He just hit module 2 of the book. Module 2 of the book is called words and phrases. Now, let me give you the game on words and phrases and the fancy law. Now, here it goes. Law is not about saying magic words. It really shows a lack of intelligence when you use too big of words, because there's no communication is effective communication. If my listener can't understand me, obviously I'm probably not talking to him. But in law, it's such a sharp genre that they use words to summarize something that they don't have to spend a lot of time talking about, because everybody reading this should know what we're talking about. Now, I'm going to give you the game on law. This is what taught me. I was no brainiac, no. Aside from your transcripts, and I'm glad he brought it up, aside from your transcripts, your indictment, and your sentencing minutes and plea colloquy and stuff, the most important thing you're going to need, it's supposed to be in your box, your food box. You need a thesaurus and a small dictionary. Why a thesaurus? Because a lot of words, you might see a word, but to understand the true context of it, look at your thesaurus. You might see a word you want to look up, and in law, unless a word is specifically defined in a statute or rule, it's given its common ordinary meaning. So look to the dictionary and you can say, hey, this means this. And when you cite the particular dictionary version to convey your point, they got to respect it. When I say this, you shouldn't have to go to that, because I used the dictionary and thesaurus so I could follow and learn what these judges were trying to say to me, because please don't read and think you understood what they said. Make sure you understood what they were saying. And that's why they cite case law, because when you want to get a deeper understanding of when they say he was denied procedural due process, like, what the heck that mean? You can go to the case they cite and it might explain procedural due process in one of the head notes, or a case in there might explain procedural due process. Because when it comes to law, and I'm going to get back to giving you the components of a case, because the book, it's a combination of every factor in this book is important to teach you to win. Like he just touched on words and phrases. Absolutely awesome. People ask me, and I tell people, I be like, I was in a class in John Hay. It was between 8th and 10th grade. I don't know what grade I was in. So I'm no brainiac from college. I am a regular person just like you who studied for my life. And as you study, you're going to grow. I had never been on a college campus. I've never been to a prom. I've never been to a graduation. I took the wrong way out and threw my life away, and we could talk about that in our re-entry components about becoming a better person. But you can become a better person. And now I went to prison, and I took my time and I learned law. And I learned for myself initially, but when I started helping other people, and people their mother's crying, they're crying, they're going home, I'm seeing them, I'm walking them up to the gate, and they giving me a hug. It was such satisfaction that I know that man wouldn't have been out without me. Mr. Derrick, I want to reintroduce him. He didn't tell his story yet. He went on actual innocence. He actually had life. So, and he's no gifted tycoon. He just refused to lose. You know what I'm saying? He was one of the first persons I saw before I came in that was in the law library trying to help themselves. So when I say that, words and phrases are important. Learn the components of a case is important, because if you don't know how to dissect the case, now I started, and I'm going to go a little further right here. You got the site, which is the case's address. That way you can identify, pull it up anywhere. A lot of Ohio site, they might be like 2015 Ohio 2339. Well, there's only one case in the world going to be there. That's that case you're looking for if you got the right site. Cases don't share sites. That's their social security number. Never be another one in the world. So first you want to do is get the site of this case. In case you lose that case or lose track of that case, you're like, oh, I got it. It was 2015 Ohio, 2239. Bam, it'll never go away. Second, you want to understand what was the question presented. The question presented, then you want to understand what was the court's answer to the question presented, which is called the holding. But now the holding is the most important part of the case because it's what a case stands for as a matter of law. If the court say he got a right to 2 counsel, or if he got a right to 1 counsel, he got the right to no counsel, if they hold that as a matter of law, that's what that case stands for as a matter of law, and ain't no getting around that. So we want to know what's the law so we can try and get out. And what I learned is that, as I said before, like there's no perfect crime, no perfect trial. If you apply yourself, you can find a way out of this or a way to reduce your sentence because, like I say, this course is not about innocence. This course is about justice. It's about fairness. You could be over-sentenced. You could have received an unfair trial. You got a right to walk out that courtroom unless they find you guilty through a fair trial process. They're not. Why? Because one, you didn't come in ready. How hard is it to be the man with a blindfold on? You play with him. You got him. But, hey, we don't got to keep being like that. So I don't want to criticize. What, you got a question?
I wanted to, just something that you were just speaking about during the process of the trial. And something that we should also look at, man, is that many of us have we've had attorneys and things like that. And so one of the things that this You and the Law, the course will also empower you with is it gives you that inspiration to kind of chart your own path. Many of us will look at it and we'll say, hey man, I got a lawyer. So we allow everything to kind of lay on the lawyer, but what I always tell people is that at the end of the trial, win, lose, or draw, that attorney is gonna walk out that back door, and in many instances, some of us, we going through exit door, stage left. And it's like you get that last little bit of conversation from your, I'll get back with you. And then that is the beginning, man. And that's where each and every, when you get that conversation, when that comment is made to you, is I'll get back with you, that should be the kickstart to you beginning to take advantage of a program such as You and the Law, a course such as You and the Law. Because, again, it's you. When you get in there and you start reading, and many of us, and this is why it's gonna be so, I'm not gonna talk a lot. I'm gonna let him get into the program and let him get into his course modules. It's when you start looking and you start looking at it's things, the words and phrases, mitigating factors and things like that, things that he's gonna talk about. But those things are they're crucial to your conviction, crucial to your plea, crucial to so many different aspects of your engagement with the law, your engagement with the court. So again, like I said, I just wanted to kind of chime in on that because that's important, man. And I think that as You and the Law, the paralegal certificate course, it's an inspiration, man. I'm here today because taking and borrowing from the things that are in this course, that's what led to you start giving your lawyer. Again, he talked about a good client. A good client is who can effectively assist his attorney. You have to help your attorney. You just can't sit there, throw your hands up, and say, I'm going to rec every day and wait on my lawyer to wait till you get your legal mail. And then when you get your legal mail and it don't say it's time to go home, you get sad and depressed. Do the things that are necessary to aid and assist yourself, you know. And that's I just wanted to, before we got too far off, I just wanted to chime in on that.
Thank you for that. Thank you. And what I like to say to keep going on that note, one side note is this course and this podcast and these newsletters, if you're familiar with the newsletters already, they come in 5 languages. They come in Spanish, English, Hmong, Turkish, and Arabic. So no matter what you into right now, I actually did the Arabic for my Muslim brothers. I'm not Muslim per se, but I love all my brothers. And when they study in Arabic, well, I'm giving you something to study in Arabic. It's law because it's going to help you. And this podcast series and the law course, it actually comes off in Spanish. So I did this intentionally because I did 25 years and I did 20 federal and I did the last 6 in the state to add up to flat 25 straight. And there's no Spanish law for the Spanish men and women. And this course is especially designed, I know y'all listening, this course, the reason I'm putting it on free, because I'm tired of seeing women neglected. Women will support a man while he's doing time, but when y'all doing time, they leave y'all for dead. So what I can do, I can't do the time with you because I'm building my life. I did 25 years. What I can do is give you the best gift I got. I'm giving you this law to help you get back home. I know it's emotional. I know it's stressful. I know it's emotionally draining. I've been there. When you get a denial, that's 3 days of sleep. You out of here. You are, listen, I don't care how strong you are, how gangster you are, you finna take a nap. So now, but the thing is, a lot of us go to trial and they'll be like, they'll tell the lawyer you with the prosecutor. So here's the problem. I'm actually not with the prosecutor. You're not with me because you won't learn nothing and come help me. So it's me against him and me against you. I got to fight him and you, and that ain't an interesting fight. I only had that happen one time in my life, and I'm just a paralegal. We went to see some guy, and he was so hostile, I couldn't believe it. He actually said, man, I know y'all were the prosecutor. I wanted to kick off to him my credentials from my past, but I said, it's inappropriate. I'm a professional now. He don't need to know who I am. So I'm going to ask y'all, please, don't get emotionally drained and charge your lawyer. If you're emotionally drained, get emotionally charged back up by learning how to help yourself. There's no power like knowing that with or without him, I'm finna help myself. So this course was literally designed to help you. All right, we got another special guest. What's up? My assistant director, Royce. You come on in, Royce, if you would, please. The movement. Yeah, this is a movement. It's live. I can't do that? Oh, okay. Why not? Okay. Okay, yeah, but this is my assistant director.
Okay, so what did you want? You want him to get in the screen with you?
Yeah,
I thought this was a training module.
it is, but we just freestyle rolling. We're gonna cut these parts out, but yeah, he's very welcome. Yeah, he just graduated law school. This is my coworker.
I know who he is.
Right.
But you're doing a module. Now you're gonna have you in the module and him in the module.
And that's okay because I want to introduce him because we move as a team. And unless it's against some rule, I definitely like him in.
Bruh, you're doing a module. You just don't have a guy up here next to you when you're training.
I can understand, but
How you doing?
I'm doing okay.
And I'm trying to explain. See, this is how he looks right now.
Yeah, he looks great.
Okay? Now you're gonna get in that picture somehow.
Yeah, there's that's the camera.
I didn't want him to get in the picture. He could have sat in that seat over there.
Yeah, I have to be in the frame.
I didn't want him in the frame. I just want him at the table in case he have a question when I go back and forth.
Okay. Well,
Yeah, so we can keep the shot how it is.
okay.
And then y'all can just come and sit down. And then,
But I wanted to introduce him because this is a movement. This is my partner. He volunteers with me. We're not paid.
Right.
So I want him to he's a young lawyer. So I want the people to know him. Right.
yeah, we
We
can
on
keep
such
the
a
shot.
roll.
We can keep the
Okay,
shot.
so
how
you
it
want me
is.
to edit, you know, I'm trying to save your money here. Okay, so you want me to edit him out after he gets into the.
No, so you
He
said
can
if he gonna sit right there.
He can sit there.
Where?
I mean, she don't have any, you have any questions you want to ask?
No, right now.
Okay, he can take that seat. Okay.
Yeah, just keep you, this is the perfect shot.
Okay,
We
okay.
can keep the
I-
shot how it is.
Yeah, I don't want to mess this shot up.
Okay, thank you. And I do, so he can take her seat for a minute, and I am going to introduce him,
Yeah,
and just because he's a part of the movement.
okay.
The movement is
I don't have a problem with
Right,
that.
right.
But you was like, you wanted to sit next to you.
yeah.
And
I was
going to mess up your shot and then, you know, editing is hard, bro.
okay.
Editing is difficult. Okay? I
Okay,
want you to have this is very serious. This is very good stuff. The questions are beautiful. Everything is great.
okay. Thank you.
This is my artwork. This is my,
Okay, I had to
this
take
is my
that.
life.
I show deep respect for you
Okay,
because I just usually would told somebody no.
So all this other stuff we can cut out. But yeah, I like Royce in there. He can ask the question. She wasn't asking any questions.
Right, because she don't know. Right. He can
He's
feed back.
familiar with the
Right.
law.
So thank you for that advice.
Perfect.
And I didn't mean to mess this. Okay.
All right. So Royce, let me get a sound check from you right quick.
Okay.
And thank you, Mr. Larry. See, he know I'm new to this, but
No,
at the
we
same
all new to
time,
this.
we're freestyle. We
Right.
roll.
Yeah.
Right.
Yeah, and if people just a podcast, that'd be great. But it's going to be a training module.
Gotcha. So this is
Yeah.
actually a recorded. I get what
And
you're
it's an
saying.
introduction though, because
Right.
they don't know our staff yet. So I'm introducing them. So
Well, you got a couple. You got the lawyer in there last week. You had Royce in there last week.
but we wanna sweep the joint.
Yeah,
We wanna become
Continue to
right. Okay. All right.
check, sound check.
So I'm gonna introduce them. Okay.
Sure. Okay.
Okay. Just tell me when to go.
Anytime.
Okay, we're good. Excuse me, ladies and gentlemen, I'm back. And what I was saying, I did this because I wanted for the Spanish population. I want y'all to have a chance to learn law. That's why this podcast is broadcast in Spanish. The course comes in Spanish. The newsletter comes in Spanish. I have never seen an opportunity for the Spanish-speaking people to learn law, but they're subject to the same restrictions and life sentences and 20-year sentences that we are. So this is a gift to you from just nature. Now, second, the women, I want y'all to please pay attention because I was so disappointed. I've ran into a few female cases from them contacting me on Nidovo, and I was like, damn, this is terrible. But I can't, fighting a case is a 3-4 year battle. What I can do, the best gift I can give you is the gift of self-improvement, self-application, self-power. I want to empower you. That's why I actually took 2 years and developed this course because I wanted to give it to the good people who couldn't afford a lawyer. Now I'm actually home finally, and I'm taking my money and I'm putting it and giving it to you on here. So now I got another special guest just jumped in, my assistant director of this movement, Mr. Royce Johnson. And I'd like to welcome you and have you introduce yourself, please, because this is the movement. Everybody here is part of this, and here we go. You got any questions? Okay. Yeah, today, Royce, what we've been discussing is the components of the case. I opened up. You got the cite, you got the question presented, you got the holding, which is, of course, answer to the question presented. Then you're going to have what's called the reasoning behind the holding. That's where I left off that before, but the reason behind the holding is important because it explains why the court answers the question presented the way it did. Now, that's very important because just to say you have a right to counsel or you don't have a right to counsel or whatever the question is, or the confrontation clause don't cover this, I want to know, well, why you say that then? They're going to explain this is why. But in explaining that, they might be say you may have this right over here, but it's not a confrontation clause violation. It might be a violation of the local state rules, but it's not a confrontation clause violation. Now, that's called the reasoning behind the holding, the component of the case where the court explains why it answered the question presented the way it did. Next, you got what's called key facts. Key facts are facts essential to the conclusion reached. And those are important because, like I said before, he could have a statute of limitations violation. You could have a statute of limitations violation, but you might have pled guilty and waived your right, and absent upsetting the waiver, which is the first way to go. When you waive something, look to see whether it's constitutionally valid. So he might win, you might lose because you waived your right, but you could upset that waiver. Now you got the same rights as him. The next one is you want to learn what's called dictum. Dictum is language in the case unnecessary to the holding. So they might say, had he argued this, he might be better off. So we'll read that not knowing law and say, well, I'm arguing this. The court said I was right. No, the court suggested that you may be right, but that question wasn't directly before them. They just gave you a hint. Hey, go over here, you might strike gold, or they might just be talking. So you want to understand dictum versus the holding and the reason behind the holding. Because dictum is valuable. They might say, but for this appellate waiver, he would be entitled to relief. They're absolutely right. So they tell the next guy, man, go after the waiver. Because law is designed to educate, case law opinions rather, is designed to educate the people, educate the legal community, educate the lawyers, educate the judges, so they can ask the same question over and over. Now, and I'm gonna just finish this. You got what's called dissenting opinions. That's where a judge will disagree with the outcome, because every panel usually has 3 judges. If 2 go this way and 1 go this way, the guy won because 2 went that way. If 2 go the bad way and say he should lose, but 1 say he should when he dissents saying y'all wrong, but no matter how he feel, the majority won. So that's called dissenting opinion. The concurrent opinion is I agree with the outcome, but I might have my own special reason. So I think he should have won for what you said plus this, that he might not have presented the right argument completely. So with that said, Royce, understand the components of a case. Could you please help me and ask some questions that our viewers may have? And introduce yourself again, please.
Absolutely. So thank you for having me on again, Jermaine. It's nice to be here today. Thank you all to the crowd that's tuning in and listening to the podcast. I think that we're going to be going over some great stuff, and reading this case law is very important because that is how you win cases. That's how you learn law. You know, even in law school, that's how they teach you the law, is you're reading case law. You're reading these cases and they're showing you how are these facts applied to the law and how are the judges coming to a conclusion. So I think this is a very important part of the segment. I think it's a very important part of the book. And I think some questions that I do have, one that you had touched on was the dissenting opinion that kind of correlates with the reason behind the holding. So in every case, should you expect a reason behind the holding?
Yes, every case will have a reason behind the holding. And by him touching on dissenting opinions, I want to go into that. I love dissents, and I'm going to tell you why, because it's another part of the components of a case that I teach in the book that I want you to learn. It's called nature of authority. Nature of authority means who does this case, is it constitutional ruling? It's a matter of statutory interpretation. That's called the nature of the holding, whether it's constitutional law or statutory interpretation. The nature of authority means who is bound by this case. Like, so say 2 went this way and 1 went this way, and the guy lost, but the one dissenting saying he should have won. Always read dissents, because it's a judge, a well-informed jurist, publicly saying y'all dead wrong. He's going against his colleagues publicly because he strongly believes this court case should have went the other way. Now you say, well, what that matter? He lost. I'm gonna tell you why it matters. Because that might be an 11th district case, and you might be from the 8th district. So you could take that argument of the dissent and present it to the 8th district. The 8th district ain't bound by nothing the 11th district said. And to give you an example, the 11th district will be Lake County, Ashtabula, and the sort. The 8th district will be Cuyahoga County. The 10th district will be Franklin. The 1st district will be in Cincinnati. So if a 1st district court say something like, hey, you don't have that right, don't feel defeated. They don't have that right in the 1st district. How does my district feel about this? If I feel I have that issue, if you feel you have that issue and it could be material to your case, see how your circuit is applying it. And then you want to see how the other circuits are applying it, because you can even go to Ohio Supreme Court, say they split. So understanding what the court said and why they said it and who disagreed and who agreed is everything, because you're finally learning the issue. You're not only learning the issue, you're mastering the issue, and it gives you the proper tools and understanding to present the issue. Is that about clear?
Yeah, that's good. I think you definitely touched on how important the dissent is and how strong it can be. Like you said, especially a judge speaking out against his own colleagues and saying, hey, publicly on it, saying, hey, I do not agree with this. That is something that is important to look at. Going, expanding upon that, I think that, can we touch a little bit more about circuit split? So when we looking at
circuit splits. Circuit splits. Ohio got a beautiful special rule that all defendants miss. Okay, and here's why the courts is also important. The courts not only teaches you law, actually, like all of your constitutional rights, it teaches to you. It gives you case law explaining each of those constitutional rights. It teaches you how to dissect case law and apply case law. It teaches you how to dissect and apply statutes. But it also teaches you all of the Ohio rules and all of the time bars in place. Because the normal procedure goes like this. You get convicted. You got your 10-day window for Rule 33. They put windows in place because only the wise going to catch it. And you don't even have to be in the unwise no more. So you say, man, I ain't know. Why didn't you pick up the law book? It's and not to blame you, no. It's time to stop. It stops right here. This course is my offer to you for free to get this on. Now, you got your direct appeal. You're gonna have your sentence, then you're gonna go to direct appeal. In your direct appeal, you're gonna present your questions. You're gonna say, hey, my conviction is bad because this, and like I told you in the prior episode, your conviction comes with a warranty. They guarantee that it's constitutionally correct, But the trick is your warranty can expire like any other one. So they're going to put time bars on what you can do. You got your direct appeal. People say, okay, I know what a direct appeal is. You might even know what a post-conviction relief petition is. You might even understand what a federal habeas is. But did you know during your direct appeal process, if you identify your question presented that you say can help you get relief, it's your job as a smart litigant to go see what all the other districts are saying. Why could you, okay, say you got a case from Cuyahoga County say you're supposed to win, but Franklin County saying you're supposed to lose. Or you got a case from Cuyahoga County saying you're supposed to lose, but Franklin County say you could have win that, and Cuyahoga County deny you. Under Appellate Rule 25, you have 10 days to alert the Court of Appeals that their decision conflicts with another one. If they find you right, they are mandated to certify to the Supreme Court to resolve the split. If Franklin County said, hey, this is right he had, y'all violated this right, give him a new trial. But you had the exact same legal question and they ruled on that question differently in Cuyahoga County or say 9th District of Summit County, you do a motion to certify conflict, which is Appellate Rule 25. You got 10 days to do it from the direct appeal decision date, and that's counting weekends. They don't even play. They wish you would miss that clock. But hey, they never really certify conflict that much. But for because none of us ever do it. It's like they might do 3 certified conflicts a year, but you might only had 20 defendants ask for it because 20 lawyers were smart enough to do it. And this is a good point why you should learn law. If a lawyer charged you $10,000 or $20,000 or whatever for your direct appeal, he didn't incorporate a price for a certified conflict motion, a motion reconsideration in bank. So if you're not familiar with law, you just lost, and there is no, hey, let's keep fighting about this. Why should he take 2 more weeks out of his life to keep fighting when you don't even know your rights and he can't get no more money out of you? So I don't mean to be, but you see, the problem is you need to know this. So if you understand what and this is how you make it easy. Not to say the lawyer bad, I actually blame ourselves. I'm gonna point at me because I don't want to point at you. I'm gonna say, if you lose, if you understood law and you read this course, you mastered this course, and you understood what a Appellate Rule 25 does and the requirements for Appellate Rule 25, your direct appeal is going to be pending between 5 months and a year. Those 5 months, you could have found cases in different districts that said you absolutely supposed to win. So when your court comes down and says, affirmed, get out of here, you're supposed to automatically have the papers ready, say, lawyer, could you please file a motion to certify conflict? I already found the cases that's a conflict. He would love to do a good job, but please don't ask him to find it within 10 days. He just ain't got the time. So you as a defendant doing this time, it's your job to help this case out. You're actually the case manager. You have the right to the assistance of counsel, but you're actually one charged and convicted. So get smart. And it's not hard. I know it sounds frustrating, I swear. Most people that I know that do excellent in law, they just had the patience to overcome their emotions, and it's hard. But use your emotions the other way. You be like, I want to go home. I miss my kids. Well, then act like it and take this course. And that's not, I apologize if it sounds harsh, but it's the best I can give you because I meet a lot of guys, they call me just last week. I don't want to call out the name. Guy called me. I won't even tell him how to win his case because it was so easy. I said, well, here, get the course, and I'm going to show you how to do this. You definitely got a chance, but you get sentenced on the 6th, so you got to file it before the 6th. He just pled guilty, but he hasn't been sentenced yet to the 6th, which is like Monday or Tuesday, because that's when we start our course at detention home. Pre-sentence with the standard to withdraw a plea is just beautiful. It's absolutely beautiful. But once you're sentenced, it gets harder, and it's still crackable easily, but it gets harder. So he's pre-sentenced. I said, man, you just need to say this, that, here, get the course on, hurry up and ship it to you, or at least have your people call me so I can ship you this chapter. His mom called me and said, well, you're not a lawyer. We don't want to know nothing from you. I said, hey, I'm okay with that. Apologize, but guess what? If you pay the lawyer $50,000, you know who's going to do the work? Me. So I was just trying to give it to you for free because I love you, want the best for you, but we got to stop playing. We got to start listening, paying attention, and taking on leadership. His mom was like, well, you're not a lawyer. Listen, lady, I know 5 lawyers who took your money and crashed and burned you. I'm trying to give you the game for free, and I'm trying to educate your son. And he's facing major charges. He pled guilty to that whole indictment. I said, hey man, they about to smoke you. Because he got that fentanyl and it's a mandatory minimum 11 to 16 years because of the amount he had. He wanted to withdraw his plea, but they can't afford a lawyer, for one. I said, hey, we got a great lawyer for you. Oh, we can't afford a lawyer. I said, well, man, do it for free. You pre-sentence, and let me give you the game on this. Tell your mom, maybe get you the course because I would love, this is what I offer the course. But she, so I'm just telling you, we got to stop being resistant. We got to start taking charge. And you never know where a blessing coming from, but the blessing is actually in you. It's my dream. Like right now, the reason I'm putting the podcast in Spanish and I'm focusing on the women prisons and I'm focusing on the men prisons also as well. I would love everybody, this course is for you. We're in 36 states and in 54 jails in Ohio, so we are reaching you. I want to start a movement where we are finally taking back control of our lives. But I can't lead you or be of a healthy friendship with you if you won't educate yourself. I'm giving it to you. If you ain't got time to love you, I definitely don't. I love you, but I'm cool. I understand I can't change the world. But if you about it, we rolling. And that's what this movement's about. Now, apologize if it sounded harsh, but sometimes the truth needs to kick in. Now, any gentlemen, any feedback on that? I ain't gonna take the
No, I don't think that there's. I think that those are the conversations, man, and we have to understand the demographic of people who we talking to.
Right.
The tough language that's the easy part. You know what I'm saying? Hearing it, it's necessary though. You know, because again, so many people. I mean, your story about the mother who. There's so many stories like that where we reach out and we looking for assistance. So but then when we get the assistance, and let's just be very, very, you talk about elephants in the room. You're not a lawyer. You just a regular guy in many people's eyes, not knowing how extraordinary you are in terms of what you're presenting. And so when you have that, you're gonna get those people who are, man, I don't want to do it. So those people, again, they circle back because it's gonna come a time.
This guy coming back.
It comes a time, right?
He'll be back.
It comes a time where we understand. No, but here's it. He will be of those, and this is what I say, and this is why it's so important. And I'll say this: the question. I'll pose it in the form of a question. When we have situations such as what you described, let's talk about that after post-sentencing, okay?
Okay.
A guy didn't take advantage of his ability to get into the course.
And the standard that applies.
And
it's just a dream. All you basically say, I'm innocent, I didn't understand the nature of the charge. Ohio don't tell you the nature of the charge in the courtroom. They don't do factual basis. So when you come with your affidavit, say, I didn't understand the nature of the charge. I'm actually innocent. I didn't knowingly have that. The court gonna say, okay, take back the plea. But once the plea has been accepted, now you're qualified as a disgruntled prisoner just not happy with your sentence. So they're gonna fight you like a dog.
And that's I want to talk a bit because that's what happens. So again, me being I'm pro fight your case. You know, I'm pro let's go to court because I think that those appellate rights and things like that come to be they come to aid you more than they come to harm you or be adversarial. Yes. So when the guy or person, we're not going because this is for women, both men and women alike. When the person accepts a plea and they're sentenced, and now let's talk about how do I get into, again, strategically, how do I get into this so that I can, because now I'm here.
Right. Yeah.
Now I realize that if whatever I say, I'm going to be viewed as a disgruntled prisoner.
Right.
And everybody, we all have watched these rooms. We've all seen people go to court and they plead guilty. And once the sentence comes down, it's not just the person that received the sentence that's upset, it's the family.
Yes.
That same mother who said that you're not a lawyer. Let's talk about how we can, or my question is, how do you approach that person now when they come back and say, hey, Mr. Levy, you know what? I know you're not a lawyer.
Right.
But what can we do to help my son or my daughter?
What I would like to say to that, caution is right. She's correct to have caution. She's correct to have fears. Her child's life is on the line. So I absolutely respect that. And an ugly fact that we don't want to state is that most jailhouse lawyers are not very good. So I'm actually, I wouldn't say exceptional. I teach law. I taught law for 18 years. I love law. So
Come on, you can say it, man. You're the best in the business.
yeah, I was called lawyer to the stars when I was in, but and I won awesome cases. But it's like most lawyers, I just don't want to. Most jailhouse lawyers, I couldn't even let them ride a kite for me. Not, and I apologize for it, but come on, get on top of your game, DM. Take the course yourself and meet my standards. I'm very strict because I'm very serious about this. So for the mother who is scared for her son, and because I'm particularly not a lawyer, I can respect it. I'm not a lawyer. I'm a teacher. I teach law. But by teaching law and teaching law in prison, the advantage I have, and that's what the lawyers tell me, is I can spot an issue that it'll take them. They'll miss it. The whole appeal will go and they'll miss the issue. But I've done hundreds of cases, so I know the issues when I see them. I wrote a book on law, so I know the cases because I'm the one who wrote the book on it. So forget me about the defendant who is facing this challenge and scared because he don't want to make the wrong decision. I understand that. Learn for yourself. It's a simple answer. Hey, don't trust me. I don't even want you to need me. It's my dream to make you smart. Okay, now go ahead.
Yeah, and I think that's something that's beautiful about the course is equipping yourself with the knowledge
Right.
to be able to help. Because you got to understand, when you hire an attorney, you are now a part of our team. I don't think that you should, hire a law firm and just say, well, I gave them the money and let them handle it, especially if your life is at the line. I would want something to do with that. You know what I mean? I'm trying to understand and see what's going on and to the best that I can understand what you're talking about. And I think that what the course provides is an ability to, and you speak on this too, is to be able to ask good questions, to be able to present issues, to be able to read and dissect, hey, what about this case? How can this apply to my situation?
I love that when my particular clients I'm working with come back and say, read this case. I was just floored. It's a guy just called me about a case called State versus Grad that just came out. It's a medical breakthrough. They said, like I told you, the Constitution was a living document. It's subject to interpretation and the want of the sitting justices. Well, they just said medical breakthroughs in Ohio. The Ohio Supreme Court just said a medical breakthrough or a change in scientific acceptance can constitute newly discovered evidence. I was like, what? And this guy, I heard of Grad because I heard of it through our firm. The lawyer I work with, William Norman, he said, hey, it's a new case called Grad. When you guys get a chance, check it out. So I was so busy, I hadn't got to it. This was about a week or two ago. And I just talked to a prisoner. Can't say the name. I can probably, but I'm not, out of respect. But you know who you are. It's two brothers. They got Grad mastered. When they dropped Grad on me, he came with a theory so interesting. I said, man, I respect you and I like you. And here's the thing. The objective of the course is to teach you because nobody will fight for you like you. So when you learn law, you learn how to see law. And this is a classic example. Grad dropped. One got life, one got like 34 years. They both all over, and it actually fits them. But now they're trying to figure out how to break procedural barriers that might be in play. Like, does a motion for new trial apply to a plea? Does it qualify as new evidence for second and successive purposes? So these are, and I told them that when they gave me the case. I said, well, when you give me an issue, my job as a teacher of law and a litigator is to understand where the opposing party gonna come from. So I said, hey, you gotta watch. You understand interest and finality. You understand, is this newly discovered evidence for purpose of a guilty plea? Is it newly discovered evidence for second and successive purposes? How are you going to get in? But the good thing about these gentlemen that I love is they presented the right question and got a lead. So you sitting there watching this right now, you could study and come up with the lead for your lawyer. I love when my clients call me and say, check this case out. If it's cuckoo, I'm going to tell you, nah, get out of here. I apologize, but we ain't going there. I ain't going there. You go where you want, but I don't waste my time. I could be helping somebody better who got a real chance with a real case. So, and I'm not going to say it offensively, but I'm going to say, no, we're not going to play these games. My job is just not to scramble for you. My job is to win. So now, with that said, if you take the course, you apply yourself, and you start learning how to work that law library the right way. See, opening up your law library is not enough. You're not trained to know what you're looking for. That's like me going to open up a truck engine. I'm looking at it, but I don't know nothing. So, but with a manual designed to help me, and this truck got to get me and my family to California, or we gonna drown in that wave, I better get to reading. So, did I answer that?
You answered. Now, and then I would like to share this, and then this is
No, you're welcome.
Here's one of the things we talk about: understanding and trying to, an interpretation of law. Now, specifically, we talked about my situation. I can remember first getting into the law library, 292503. That's drug trafficking in the state of Ohio. Now, one of the things that I used to, and it was a number of people who used to sit and we used to talk and bounce ideas. You know how it goes in the law library. And situations that were very prevalent back in the 90s. You know, the local municipal vice unit run up on the corner. It's 5 guys on the corner. And there was an empty field, and there's a bag of rocks in the bag, and they pick up that bag of rocks. And all 5 of those guys would be charged. Well, one of the first things that I read when I got there was that does not, it defined the 2 types of possession, actual and constructive.
Right.
And one of the things that it used in the case is the constructive versus actual possession. And I say that to say, these are the things that this course does. It causes you to see those things, because there's a lot of guys who were sitting there with me, and they had been subjected to that very situation.
Let me tell you why those guys could have benefited from this course and why they're in jail versus being free. They didn't understand something simple that we're not taught, that I teach in the course. What you just touched on, Mr. Caesar, was called the actus rea and the mens rea. The mens rea is the mind state necessary for commission of the crime. Right now, if Mr. Caesar has something on him and they raided this room, I'm not guilty, because I didn't know he had it. I didn't intend for him to have it. And excuse me, he's not that type of guy.
Right.
Just give you an example according to what you
No, I
said.
got
You got to knowingly possess something, whether it's actual or constructive, and you got to intend for the operation to go down. So that's why I say knowingly is everything. Like, if I know a guy, car thief, he can't get me a ride. Absolutely not. I'm walking or I'm catching a bus. So we got to exercise caution in our things. So like, if a guy throws something by your feet, they got to prove that them drugs is yours, and they got to actually prove you threw it down. But it ain't hard to believe that at your feet. But you got to understand law, so you can say nah, and you got to. Most of us as defendants, this is another constitutional thing that you need to know. They say the feds win, like, they got an 80 or 85% conviction rate, but they say they lose. They got a 63% loss rate when the defendant takes a stand and testifies on his own behalf. Most of us don't testify. They're like, you got a prior, don't testify. Well, I'll tell you this. I might have sold some drugs before, but I ain't no robber. I ain't no a lot of crimes. We just gonna leave it like that. So defend yourself. And I'm gonna tell you, and I try my clients like this. I play with them. I be like, they're called, we'll be talking. I'm like, yeah, I heard about you before. You the dude be kicking boxes, right? That's in jail breaking somebody's locker. So he be like, no. I said, but they called you a rapist and you sat there and remained silent through your whole trial. And they just be floored. You defended against me about something that means nothing. But he sat there and called you a rapist, kidnapper, everything, and you remained silent. And now here's the problem with that. The jury only heard one side of the story. You praying to God, they don't believe it. They had 3 witnesses get up there and say this and that and this and that, and you presented none, and your lawyer got up and said, well, they didn't prove their case. Well, you gave them no hook to hang a not guilty verdict on. So I learned that, and I learned that defend yourself at the right times. And the right time is when you're being accused of crime. But it's after the fact, so we're not going to cry over spoiled milk. But I can tell you this. Even if you made a mistake, you take this course, there are errors in your case. And now here's the problem. You might be time barred, but you can come from under that time bar. I just gave you a perfect example. Say you had you're wrongfully convicted, and your case is based on DNA, because that's the nightmare in Ohio. When I thought a person's convicted of rape, I thought, like, wow, I didn't learn. Oh my God, it's being misapplied in Ohio. So to say that you might be time barred, you might have lost everything, but they can come up with a case that's interpreting a particular statute you're convicted under, and that opens a whole new window. Why? Because it's retroactive, because they interpret the statute. It is as it always was. And I can give you a perfect example just for you out there who want to test my knowledge and see if I'm a good leader for you. And please don't forget this case right now. It's State versus, it's 2020, and I can't think of the name of the case. It's in this book though. But I apologize for jumping out there with that, but I'm gonna tell you what it say. They said forcible rape is not when you're the football coach, or say like she the babysitter, or he the coach and she's a 17-year-old girl and they mess around, have an affair that was otherwise consensual, and he gets statutory rape. They charge, or they charge with actual rape by force because he coerced her through his influence on her. I'm not saying it's right or wrong. I'm going to leave that respective and pray to God that the person wouldn't do nothing wrong. But I'm going to say this. The Supreme Court of Ohio said that's not forcible rape. That was actually statutory rape. But here's what goes. You got 1,000 men in jail for that particular scenario. All time barred, all been 18 years. But the day the Ohio Supreme Court said that doesn't meet the requirements of their statute, that was a new retroactive rule which gave them a new window. So I don't know if I'm explaining that right, but say you're convicted of something, and they say, well, that don't fit that statute. Well, you say, well, I'm sitting here convicted. The day they said that don't fit that statute, you can come straight into court. But guess what? You won't. Want me to tell you why? Because you ain't read no law. You thought you was dead. You ain't never dead till you give up. The law evolves, and I'm telling you this. Like the case with the I won't remember that case, but the case with the grad, where they just said new medical evolutions can constitute a viable basis for a motion for a new trial, totally out of time. That's an awesome decision. So everybody who got these medical scientific theory cases can use that. The Supreme Court will open that door, but guess what? They'll slam it back. Like, I'll give you a perfect example. You're from Ohio and you've been in jail a long time. They had a case called, I think it was Comer. You remember that case, college, from the 90s or 2000s? They were saying if the mens rea ain't in your indictment, it's supposed to be at least recklessness. If recklessness wasn't in your indictment, they was letting everybody go. Oh, it was a floodgate. They closed that door. And they got it tighter and tighter. Now they don't put semen over it. So what I say is, you know what I'm saying? They don't put semen over it. So what I'm saying is, if you know the law, if a guy would have been abreast in law, he would have saw Comer drop. I think it's called Cromer, because Cromer's the Sixth Circuit case on confrontation. But those who I'm telling you, it was. They said it was dealing with the mens rea. They say all indictments must have a minimum mens rea unless it's strict liability crime. And if it didn't say the mens rea of at least reckless, and the way they was doing it was the robbery convictions. They were saying the mens rea for robbery is recklessness because the statute doesn't identify mens rea. And they was saying, well, them indictments they was holding indictments void, let them guys out for about a year. Then they tightened it a little bit. Then they got another floodgate of guys get out. Then they said, we've not finna empty our jails. So they closed the door, they tightened it, and now it's horseplay. So I say that to say, if you learn the law, when it dropped, you'll be dead on point. I'm only asking for 2 hours a day, and I'm giving you the law. This course is designed beautifully just for you. And now to go back into the course, let me see. We was in Module 1. I was telling you I want to, Module 1 got the pre-course tips. Number 1 was carefully select and frame your claims. That's saying, if you get denied, you say, was it a confrontation clause violation that happened? And they say no. It could have been a denial of effective assistance of counsel, because they will do that. You'll say the confrontation clause was violated and such. They say you don't meet plain error review. But your real charge should have been against trial counsel failing to timely object. So number 2 is, if you're a state prisoner, frame your claims under federal constitutional rules as well. You say, well, why? Because if the state tell you the state constitution and the state rules are one thing, but then you got the federal constitution. Federal constitutions establish the minimum standards. Every right you got in the state, you got it federally, also in the federal constitution. You're a citizen of Ohio, and you're a citizen of the United States or whatever state you're from, and you have constitutional rights under each of their constitutions, which are individually protected. So if the federal one is the minimum standards, the state can give you more rights, but they cannot give you less. So with that said, you might got a concrete violation of the law established in Smith versus Arizona, which just came down last year on confrontation clause. But you might scream, he violated evidence rule 801, blah, blah, and you might cite all state rules. So then the state tell you get lost, and you know you're right because Smith versus Arizona is saying you're right. But when you go to federal court and say, hey, man, I fit Smith square, they're going to say, well, you didn't argue it earlier. You got to get a state court first shot at correcting the federal violation because the feds will come in and check them. If you argue with them all downstairs, saying, hey, you violate my federal constitutional right to this, and here go the cases on it, the feds will get on their line. It's hard there too, but if you don't argue the federal right, when you get upstairs, they'll be like, get out of here. Yeah, you kind of get out of here. So that's just the truth. Now, number 3 is I told y'all that to request and gather all your records and transcripts. Pre-course tip 4, I got the first, and this is what everybody touched on. The first 11 things to review in a criminal case. Number 1, I have your indictment. Number 2, the statute convicted. Okay, let me explain to you why. Okay, your indictment is allegation. They saying you did this. The indictment got to have all of the elements in the offense in it. Like just say possession of drugs. He knowingly possessed Zanzibar schedule. I'm just using an example, blah, blah, blah. So you've been accused of, you've been informed of the accusation. Now you got to go read the statute because the statute might say he may have knowingly and purposely did this. So you say, hey, the word purposely in my indictment, so you got to challenge the indictment facially pre-trial with a proper objection to get a lenient standard review. If you don't, it's going to be under plain error. You damn near dead. Excuse my language. But the third one, in cases involving a jury or a bench trial, you want to get the jury instructions. Listen, and this is a good tip. I love law, and I'm considered a hired gun, a killer. When it comes to law, I'm saying. The baby of the case, I'm reading the transcripts. I go through the voir dire just to make sure they ain't make no blatant errors there. Then I'm going through the trial testimony and say what this witness said, what that witness said. First thing you want to also look for in any trial when you're reviewing your case, what did the lawyer object to? Because he might have had a point. The court might have said overruled, and he might have been dead right. So he objected. Now you're on appeal or whatever. He handed the ball to you. You got your transcripts like I told you to get. He objected. Now, are you going to make the right move and research and see was he correct? If you just let it sit in the transcripts and go under the bed, that's on you. But he did object and do his job. The court overruled him. So you would think that he was wrong. No. Every case that won on appeal, the court ruled against him in the lower court. So now what I was getting to, when I read trial transcripts, the absolute baby of any transcripts is the jury instructions. Because they're human. They make so many mistakes, but it's up to you to catch it. Now, if they didn't make a mistake, it may support your other claims so strong because the jury instruction, and also now, jury instructions are one thing. I look to the jury instructions when it's like, when I usually got the average self-defense case or murder case or such. I'm going to read the whole trial, but I'm hoping to go to the jury instructions because they make so many mistakes there. But second, the closing arguments. That's where the prosecutor lay out their theory of the case and why you should be convicted. If evidence was admitted improperly, and say your lawyer objected, say, hey, I want to object, he say overruled, you know what the prosecutor going to do? Prosecutor going to harp on it and close the argument. You saw the testimony. Dr. such and such said this. He's guilty. Da-da-da-da-da. But if that evidence was improperly admitted, now you can prove prejudice because when you make any claim of error, you also got to prove prejudice. You can proving prejudice mean that this error contributed to the verdict. So when a prosecutor is selling their case to the jury in closing arguments and they rely on their evidence, how could they rely on that evidence? How could they ever say that evidence didn't contribute to conviction? You highlighted it during summation. So it's tricks to the trade. So that's why number 4 in the pre-course tips is on the first 11 things to look at in reviewing a criminal case. The fourth one is in cases involving jury or bench trial, the jury instructions. I tell you that for a reason. I know I'm talking fast, and I talk because I love this subject, but I'm kind of quiet. If I tell you something, it's something there. You know what I'm saying? So I'm not trying to entertain you. I'm trying to teach you, and this is honest. So number 5 says, and here it go, in cases involving the jury or bench trial, opening arguments and summation. I just explained it to you without looking at the book and seeing it's actually number 5 because this is the truth. This is the absolute truth. This is where I'm going. As people, lawyers hire me to review transcripts and identify errors because I'm going to find them. I'm going to find them. Not because, it's because I've read a lot of law. I love law, I read law. So when the Supreme Court of Ohio or the United States come down and chastise the government, they've been doing everybody like this. So when they finally correct them, look at your case too. And while you're on appeal and you're reading all these decisions, like, oh, this is wrong. And I can give you a perfect example. I just cracked a case for a guy, dead guilty. Wasn't a question. But he wanted his plea back. I said, you sure? Because I said, I'm likely the one can get your plea back. I said, I specialize in pleas because I know what to look for because I know all the tricks of the trade with law. Judge did an awesome job. Now, when you go in to fight a plea, here's the problem. You're trying to tell that judge, my plea is bad because you didn't do a good job. He's going to say, well, prove it then. So you better be versed in law. And you can get versed in law in this book. It's so easy. This judge was meticulous. He covered this guy. Said, oh, man, I don't know. Woo, he did his job. Because sometimes that's going to be the conclusion. He did his job. But in the last instance, it's a new case drop called State versus Bishop in like 2018 or 20. They said to make a knowing, intelligent, voluntary plea, if you're on PRC when you committed the instant crime, you must be told that this judge is finna take your plea, has the authority to sentence you for that PRC violation, even though he ain't the one put you on PRC. It's State versus Bishop. So out of everything that judge went, and guess what? It was kind of weird because this guy, so the judge really didn't make a mistake. This guy was on direct appeal when Bishop came out. And if you're still on direct appeal when the case comes out, it automatically applies to you under Griffith versus Kentucky. So he pled guilty in like June. In December, they ruled on State versus Bishop. I get his case later, right now, and he's trying to withdraw his plea, but under Rule 32.1, you could do it at any time. So I just got to prove that Bishop applied to him. So I went to his indictment. I went to his docket. I said, hey, he pled guilty in June, but Bishop ain't dropped in December. But then I read further. I said, oh, he engaged in direct appeal. I said, got him. So the judge really didn't, that judge was meticulous. He didn't necessarily make a mistake, but the courts, I told you the law is what the courts say it is. In 2018, Ohio Supreme Court said to be valid, you must tell the defendant pleading guilty this too. Well, the judge didn't tell him. And I said, now here's your out. Your case is cracked. They can't dispute it. And the court said it's not subject to harmless error review. If you didn't tell him, withdraw that plea, I ain't trying to hear about it. So I said, here go yo. So I handed it back to him, and I gave him the danger. He was kind of wise. I said, listen, man, they caught you on the scene. You confessed. If you go back to trial, they gonna smoke your boots. And I say that to say they're gonna give you probably 65 to life for something crazy. So I said, what I would do if I was you, I'd take a different route. I suggested him a commutation. I said, now, yes, I earned my money. I cracked your plea. I can get it back. It's going to cost you some money. You got to pay us to represent you at trial too. But you confessed. They caught the gun. They caught you at the scene. Everything. I said, sometimes you just want to know where you can get out if you ever need to get out. But his situation was that rare one where I said, man, he had like 22 years, but he committed murder in front of everybody. Flat, no tail. I said, you kind of got lucky. So I say all that to say this book can arm you with the intelligence necessary to confront your situation. For everybody, it's a way out, but for everybody, it ain't gonna be the same. When I say that, my way out ain't your way out. His error ain't your error. His error ain't your error. You need to find your error, but before you can find your error, you need to learn some basic law, how to dissect a case, how to properly read a case, how to dissect a statute, how to dissect an indictment, how to read transcripts. What are you looking for? This course covers it all. So that was number 5. And I say in case involving a guilty plea, you need a plea colloquy because that's what a court, like a lot of courts do a great job. But some courts, they smart as heck, but they might be in a rush that day. You decide to plead guilty today, so they rush you through it and they miss something. Now, 7 is the seminal cases governing statute convicted, like bishop governs guilty pleas. So you need to be a bishop. Ain't no mind blowing case. It was just a new seminal in the guilty plea area, and I keep up with the guilty plea area because it's my job to crack pleas and vacate pleas. The number 8, I got each point objected to by counsel pretrial, during trial, or at sentencing. That's what I told you before. See where counsel objected. The court gonna say overruled, but the counsel might have been right. So you want to back him up. That's why I say this is a joint fight. The fight is going down. It's just whether you're gonna jump in. So, and it's your life on the line. So I recommend it. But instead of criticizing you, telling you how you could be better, I'm giving you the tools. Like, here. You know, I ain't gonna keep preaching to you. I'm giving it to you. I want to know who ready, and let's go. And I really did this because I met some awesome people while I was in. I feel sorry for the female community, the Spanish community. Y'all getting abused from me because y'all doing life in American prisons with no Spanish law books. That's a nightmare. They're doing the same sentence we're doing. Don't speak English, don't read English, and all law is in English. He has no chance, so I don't like that. So these podcasts, my book, everything's translated in Spanish. I did that intentionally. Let me see, the last thing I said, the basis for the trial court's ruling, like I tell you, to look for each pretrial motion filed by counsel. Even though God overruled, you want to see the basis for the ruling and then see what's the court right by checking the scope. And when you check the landscape on the issue, like I told you, you're looking for the landscape in other districts as well because you're preparing yourself for a motion certified conflict or a petition for rehearing in bank, or to go to Ohio Supreme Court, or to go to the United States Supreme Court. And you want to make sure it's federalized so you can even go to the United States Supreme Court. So all of it's a recipe. I'm giving you the ingredients, but you must know every ingredient to bake the proper cake. So now, I've been talking a while, and I've been bum rushing y'all, so I'm going to slow down and ask for any questions from y'all.
One thing that I just wanted to say, just kind of in closing, and one thing I think is beautiful about this is more so what I want to go back to what College had touched upon. I mean, he gave you a real life example and real life story of that. He didn't go to law school. He never had any prior reading of the law. But when he said when he was in, one of the first things he did was go to the law library, and he opened that book and sat down. And what he was able to do was able to understand and read, and he learned the difference between possession. And that's something that he didn't know prior to. And I just think that's something that's beautiful and to harp on, because it should give you hope that, you know, if you can read, you have a chance. You can understand, and you can take your time to go and learn. And it helps equip you with knowledge, and it helps make you possibly make better decisions and know how to possibly move forward. So I just wanted to touch on that part.
Mm-hmm. And he was actually innocent. He was like one of the real cases actually innocent. That's why he went straight after the possession thing. I recall a situation where he got caught with some drugs. They really weren't his. He had no idea. And luckily, and because he wouldn't cooperate, they gave him to him and gave him life at trial. He thinking, his name is College because he was a college student. Wrong house, wrong time. And he did what he supposed to do as a man by saying, hey, I apologize, it ain't mine, I don't know nothing else. And they said, okay, well, guess who's going to try? They took him to trial. But luckily, he won. So awesome. God bless. It's beautiful. I thank you, gentlemen, for being here. And I thank you for watching. And please send your questions in. I'm on the tablet at Onidovo. You put in, but just through your GTL email, it's info@youandthelaw.org. That's YOUANDTHELAW.org. Connect with me on the tablet. Give me some questions. And I did want to say, to clarify, I get all your messages saying, could you please take my case? Because I honestly, it's a 3-4 year project when you take the average case, and I really don't have time to run a clinic. I'm not funded. I'm here because I care. I'm paying for this. I care about y'all. I'm trying to teach y'all. This is not government funded. This is part of my paycheck because I'm putting my money where my mouth is, and they are too. These are volunteers, and we making moves. We're going to start teaching detention on this Tuesday, and we're giving all them young men jobs to graduate from our program. So I just feel your pain. I'm the same guy that was on visit. I loved it, my visits. I'm the same guy who used to get food boxes, the whole 9 yards. But when I got out, I just didn't turn my back. It ain't about turning my back. It's about being my best me. But we all can play a part. Like these gentlemen are playing a part. And Royce graduated law school. He doesn't have the history we have, but he has the input. We need strength from every part of the community. You have us as ex-offenders mixed with new up-and-coming lawyers, and you're going to see a lot of my guests are going to be also people who really we care about you. You think, of course, you get kicked around and think nobody cares. People do care, but here's what I'm going to ask you. If you don't care enough about yourself to apply yourself, it's going to draw a bar in our attempted friendship. So anything you like to say in closing, College?
Well, no, I like to say, I mean, I think that it is vital to employ just what he just said. It's vital that you employ your own effort, man. Everybody that is sitting, I implore everybody that is sitting in a cell, in a dorm, in any situation that you are not happy and content with, to take strong and wholehearted advantage of this course so that you can help yourself. If you are not willing to help yourself, then you really, really, really can't expect for anybody, unless you just expect for something to fall out the sky and the law to change and them to start opening doors, which everybody that's in there know that doesn't happen. I mean, my last little funny thing, I can remember being incarcerated in the year 1999, and it was December 31st, and everybody was talking about Y2K. And dudes was sitting by their cell doors waiting on the computer to pop the doors open because we gonna run. We gonna run. Everybody was ready.
I don't mean to
but
laugh, but that was
that's
crazy.
not gonna happen. And I'm using that because that is how idiotic the ideology of us just sitting around waiting on things to happen. We've got an opportunity here now. You and the law, this paralegal course is very, 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 very helpful and can be very informative, and it can help you with your situation while you're, currently dealing with some conviction or some term of incarceration.
Okay, and what I want to say on that, interesting, you popped up what you actually, I want to ask you a question to show you, the viewer, how simple this is and what this is real life. What does implore mean? You just used the fancy word on me. Okay.
Oh, yes. Okay, yes. So it's again, like we talked about using implore is another word, a synonym for implore, a word that means the same thing, is I strongly encourage. Implore is, you have encouragement and then you have strong encouragement. So I strongly encourage.
It's like begging.
I'm basically begging. Yeah, there you go. That's the better way.
But I just caught that word. I understand what implore means.
Yes.
But that's how law is. It sounded fancy. I know it went over. You can't tell me everybody here understood what implore means.
Right. For those that
He used the instead of saying I beg you, he said I implore you, because it's your job to upgrade your vocabulary. So he's not wrong. He's not trying to be fancy.
Right.
His vocabulary has been upgraded, but it makes you a better person when you come home. Listen, man, let's have some intelligent conversations.
Absolutely.
But to do that, we got to start reading better. And it's just like, if you throw a man in, and I use this as my example, when lawyers be like, man, how you know this? I'm like, if you throw a man in a cave with books for 20 years, he's going to come out well-read or very in the dark. And I read. So you can read, and that's why commendable for me. You actually went to law school, graduated, and you're only, what, about 23, 24? Well, I don't mean to, but I'm so proud. It's like just a young black man just graduated law school.
No, absolutely.
I met him and immediately said, can we team up, and we work together now.
Yeah,
you know what I'm
absolutely.
saying?
It's been beautiful.
So I say this to all of y'all. That's why I say I use that example to show you, just like he said the word implore, and I was like, let me call him on that, because he didn't mean no harm, and the judges don't mean no harm. But that's why you need a thesaurus. And it's just like he said, he gave his definition as strongly encourage. I gave my definition to simply beg. Your thesaurus will give you them different ones, so now there's no word can go over your head. You need a dictionary and a thesaurus. And this law course right here.
And one thing I just want to hope, I just hope that, I'll just kind of sit here looking, but I just hope it gives the people hope. It just shows that it's possible. We aren't just some superstars or just some people who just have these special abilities. It's just we just sat down and went and put in the work. And if you're willing to do that, I think you're able to actually come up with something. So I just,
It's a part of growing up. And I can tell you, I thought of it, but I didn't want to say it, but I can go ahead and say it. When I was a juvenile, I was in detention home. So when I got an adult, I didn't learn anything. So I went back to jail for my first time way back. Look, horseplay case. But when I caught this big case in the late 90s and I went to jail, I tried to read a book that I thought, when I was in detention home, I loved Donald Goin books. When I got grown as a man with kids and a father and just got stripped away from my family, it was so insulting. I couldn't waste my time. So I say that, grow up and let's read some things that can beautify and better your life. Love is an action word. So you say you love your children, you want to go home. Well, I love them too, and I don't even know them, and this is my gift to you. So I just ask you to take advantage of it. And with that said, we're going to close out. I'm going to hand it over to Melissa, and thank you for tuning in. And that was this segment of You and the Law. Okay. Did we talk too much, y'all? We'll get it. We'll get it.
You'll figure it out.
Yeah.
Melissa, why don't you say where he was, and then go ahead and do what you got to do.
Okay. Okay, appreciate it. Y'all think? What you think, College? Did you enjoy yourself?
I did. I told yes, absolutely.
You can't be coming in here trying to outdress me, man. I am salty. He came in with the leather on me.
Used to it now.
Oh yeah.
I ain't gonna miss.
Oh, shots fired. Okay, all right.
All right.
Okay, so what is she going to do?
Just an outro off the top of her head. What you would like to say?
Brother, just say anything.
Well, she's going to.
Kinda.
You know what you want to say?
I've been holding something in the whole time, but I was thinking
Talk.
of incorporating in the
Okay, in your closing?
yeah.
Shoot.
I'm thinking, hold on. I'm gonna say it before I say it, but I was gonna say to use your voice, and nobody's gonna care about your case as much as you are. Okay. But what's the first part? What's the first part?
Just want to say thank you for tuning in. This is
Okay.
This is for
Okay.
people, for people.
Okay, now, you know what? Now,
I want to know how you want to start it off.
talking some sort of fuzzy thing.
Me?
Okay, cool. All right, go ahead.
I'm gonna try not to move.
Take your time and look at that white second little thing.
If you do me a favor, just move over a little bit this way.
To my right.
Them little-
Okay, perfect.
Oh, I see.
Yeah, perfect. There you go. Thank you.
Let them have it. Be host, attractive host. Let's go. Smile. Be yourself.
Wait, is this my microphone? Yeah. Okay.
Yeah, it's her hair showing. It's
It's showing,
yeah,
shining.
Shining. It's like, okay, now it's fine, but hold on, let me see if I can fix it.
Yeah, because that's that glow that was there before you got it off.
Yeah. but
It's the glow on the back of the chairs. It's like the chairs
Yeah.
got like a,
Yeah.
I mean, it's not.
and her hair too. It's like a, it's not her, it's not you. That's a glow that's from that, yeah, from the lighting system somehow. He'll get it. He got it before you.
Hey, I'm gonna move. I'm gonna slide out.
Thank you
Go
for
use the
joining us.
restroom.
It's down
I know. I was so happy when you came. I'm like, we'll have to pee.
That shut down there. Okay. Right there.
All right.
Give me ideas. Just
Um,
say random stuff so I could piece something together.
I would say,
Put it in after. 'Cause that's
just
not
say
gonna work.
thank you for joining us from the people for the people.
Okay, so thank you. Start with a thank
Yeah,
you.
And a movement to enrich you. And please take advantage of it. You speak Spanish?
No.
Okay. Okay.
I was gonna troll you and be like, un poquito.
Okay.
I'm lying though. I don't know how to speak Spanish. I'm
Be
not gonna say that.
yourself. Be no, just outro because we can redo it over the phone or something. You just want to do an outro and then have to be a face, so you can read over the phone and get it edited. But just give you a try here, so you can't mess up.
You see that camera? Yeah, push that top button, it says, yeah, the top, thank you, sir. And then press that top one again.
You gotta put him
Thank
on
you, sir.
payroll at
That's
this point.
perfect. That's perfect. Perfect.
You might as well hire him.
All right. On hers, I'll just put it in after the fact because,
It's glitching.
it's glitching. It's glitching and switching, so I don't wanna mess it up. Okay, so anytime you're ready.
Thank you for joining us at You and the Law. If you have, dang it,
I can't hear you.
I know, I gotta be louder and work on
Yeah,
this.
Thank you for tuning in today. We appreciate your attention. If you have any questions, please submit them to info@youandthe.law. We look forward to seeing you on next episode.
Thank you for tuning in at You and the Law. If you have any questions, contact us. If you take anything away from today's episode, I would recommend using your voice. Nobody is going to care about your case as much as you will care about your case. And thank you for joining us today.
Okay, now say it with like.
Maybe do it again. Okay.
Say it like I'm an old man.
I need like a
and I can't hear you.
practice.
And I can't hear you. I can't hear nothing you
Okay,
say.
okay. Yeah, I told you I'm going to have to yell. Okay.
Go ahead and yell. That's fine. Go ahead.
Thank you for joining us today at You and the Law. If you take anything away from today's episode, I recommend using your voice. Nobody is going to care about your case like you will care about your case. Take action today, and if you have any questions, please contact us. Thank you for joining us. Dang it. Almost.
Awesome.
Hold
That
on.
was assertive. You got assertive instead of just
I know,
being
because I
pretty
have to
humble. You
think
talk
of
the
something
people.
to fucking say.
No. You,
I'm going to do it one more time. Hold on.
you did great. Be assertive.
I'm not like the most assertive person, so I said part.
You
Okay,
were
let's-
there. You were excellent. That was assertive.
Is it still rolling?
Yeah, don't stop.
Thank you for joining us at You and the Law. Today, I recommend you use your voice, take action about your life and your decisions. Nobody is going to take. You guys are staring at me, please. Because I lost it. Okay. Here we go. Thank you for joining us at You and the Law. I recommend using your voice and taking action. Nobody is going to care about your case as much as you are. If you have any questions, please contact us. Again, thank you for joining us today at You and the Law. We got to piece something together with all of that.
That was nice.
Yeah, that was good enough. I can work with that.
A little bit better, but I got to like...
It's still recording. You want to shoot? It ain't never gonna stop recording.
Thank you for joining us at You and the Law. Use your voice and take action today. If you have any questions, comments, or concerns, feel free to reach out to us. I know I can't remember what it's called.
You and the law. Remember the movie? Okay, I can give it to you. See, the movement is called You and the Law. Our thing is just info@youandthelaw.org.
And I gotta yell.
Oh, 'cause you might
Yo,
see it.
look the other way.
I just see it.
Close your eyes.
I just see it.
I'm gonna get it. I was thinking about doing that last hour, just maybe pay for it for editing. But let me let her finish. We'll get some because
Thank you for joining us at You and the Law. Take action today and use your voice. Educate yourself on your case and what you need to do. I like what I originally said. I can't remember what I had said. I said to use your voice. But I feel like that's so like, I'm trying to like clean it up.
No, I'm saying, I think that you, when you added the part, when you said, if you take anything, if you've taken anything, hold on one second, my daughter's in Greece.
Yeah, I'm trying to remember the first thing I said, but I want to make it like better, but like, I feel like I get to overthinking and I fuck it up.
What was you trying to say?
I mean, what I genuinely, I thought that was my phone, got from today, using your voice. And if you don't care about your case, then nobody else is going to care about your case, you know? Like something along those lines. But I feel like how I'm saying it is so vague. I was trying to make it sound like more like sophisticated, but
I mean, so you gotta think that who we talking to, they gonna understand the vagueness of it, so it ain't gotta be nothing crazy. Just wanna be real.
and then I'll be trying to remember everything else.
I'll be like, thank you for
And I can't yell. I got to remember to yell.
Don't yell. Just speak louder.
I know, that's hard for me.
Thank you
No,
for
it ain't.
tuning in today. We appreciate
I swear,
it.
You're a black woman. You can
I'm
speak louder
soft
as you want.
spoken, and nobody could ever hear me. But that's why I relate to it so much, because you need to use your voice. Seriously, I watched Legally Blonde today. Have y'all ever watched that? You should. It's cute. It's so pertaining to this. It was weird how it's on brand.
Okay, he only has a few minutes left on his time, so go ahead and get it in, and then
Okay. I'm gonna do one final like shindig. Thank you for joining us today.
Thank you for joining us today on In You and the Law. We appreciate you tuning in to our episode. We just want to say that if you have anything that, or or you would be like, thank you for joining us in today on the You and the Law episode. We appreciate you watching. You can always,
Thank
if you
you.
have any questions,
Appreciate
contact us at info@youandthelaww. And then nobody's going to care about your case as much as you do. So use your voice and use your ability to sit down and learn.
Yeah, use your voice. Okay. I'm trying to remember that note. Okay. Thank you. We appreciate you.
Any questions?
And I'm trying to think of what order I want to say it in. Thank you for joining us. Thank you. We appreciate you. Info. I know those are 3 basic things I want to say.
And then say,
Use your voice,
yeah.
and nobody will care about your case as much as you. Okay. Thank you for joining us today. You and the law. You and the law. You and the law. You and the law. Every time I go to say it, my mind goes blank. Thank you for joining us today at You and the Law. And then I forget.
Thank you for joining us. I'm about to close this out in a second, bro.
Thank you. We appreciate you tuning in.
Hold
Info,
on.
youandthelaw.org.
Tell him to tone it down out there, would you? No, you can't close that. Just tell him that.
I know we have something already, but if I could eat one time. Oh, thank you, Lee. Thank you for joining us at You and the Law. We appreciate you tuning in today. If you have any questions, comments, or concerns, feel free to reach out at info@youandthelaw.org. Use your voice. Nobody is going to care about your case as much as you will.
Perfect.
I wish nobody was in the room the whole time.
Perfect. There you go. So we walked
I
out
could have
together.
did better than that.
So you didn't
Yeah, I wanted you to leave too.
Right.
Yes.
Be by yourself. Okay, who's next? You
I
gotta
wanted
say
to do it again, but
The other guy